So tonight we're going to cover a couple of different areas with respect to specific witnesses. So we've talked a lot about generalities and impeachment last week. So this time, like, what do you do with specific case types? So I am going to talk about sex assault cases and drug cases. And then Kyla, excuse me, is going to talk about experts and impaired cases. So while all of the overviews and general information about cross-examination is similar, there are going to be some specific differences to these types of cases. So I don't know about you guys, but I do quite a bit of sexual assaults. My note to myself is, let's talk about sex. A lot of them seem to be coming up more and more. And when you're dealing with sex assaults, you're dealing with a particular set of witnesses. So of course you've got your complainant, and sometimes, and I say complainant, tends to be a more vulnerable witness, not necessarily, but I treat them at least initially as a vulnerable witness, and then we see how aggressive they get. But you might also be dealing with a child if there's an allegation of sexual interference or sexual touching. So you need to consider some issues with respect to those. There'll be other civilians, of course. Maybe there's some corroboration or lack thereof. And then you're going to have police. And police might be important, particularly in terms of the disclosure. Hold on one second. Sorry about the cough. It's the ash in the air. It's killing me. It's really affecting my asthma. Okay, so then you're going to have various different persons that you could end up having to testify. So assuming for the sake that it's probably, as most cases are in sex assault, a he said, she said. So there's kind of two fundamental areas of cross-examination here. First of all, because it's likely going to turn on the version of events, and you need to point out to your judge, of course, that she could be consistent and your client could be consistent. And if you can't really make out the truth between the two of them, your client should still be acquitted. But a good cross-examination of the complainant, as well as, I think it's equally important, is preparing your client to be cross-examined, right? Because you just want to tell us your version and throw him up there or her up there. It is really important for him to be prepared, or her, but usually him, prepared for the cross-examination by the Crown. And know your audience. Who's your Crown? Are they younger? Are they more senior? You do this long enough, you find out which ones are good and which ones, maybe don't need enough preps to know your audience, your judge, and your Crown. Sexual assault cases, particularly when it comes to cross-examination of a complainant or surrounding witnesses, are full of what I call ethical landmines. They're everywhere. And because there's so many ethical landmines, almost as soon as you get, remember, Kyla and I've been talking a lot about prep and making sure you're ready to go and you know your case. But at the same time, in thinking about that, you always need to have your mind tuned into, is there going to be a 276? Is there going to be a 278? What kind of 278 will it be? Did your client give you text messages? Is there a third-party records application? Does the complainant indicate that she told Sam, Tom, and Gary about what had happened? Do you need to get those documents? You've always got to start there. 278s, 276s, and that they seem to just be blowing up trials recently. I had a 3-day trial that ended up into a 2-week trial because these issues can pop up, right? Yeah, I didn't say it to the police, but I told this person. Oh, yeah, I didn't say it to the police, but I texted this person about it. Oh, I didn't say it to the police, but he's done this to me before, right? Now you're the 276 range because we can't predict what witnesses, and particularly sexual assault complainants, are going to say. There are one of two camps. They just kind of show up and they do what they're going to do and what they said. Or when they're challenged, the cross-examination is going to challenge that witness. When they are challenged, they want to, I call it the yeah, but defense, right? It's a qualified agreement. Well, you agree with me, man. The first time I spoke to police was September 6th. Yeah, but I spoke with a friend who's a police officer and a neighbor a week before that, et cetera, et cetera. And then you need to make sure that you're not following any twin myth reasonings, that you are going with respect to the twin myths. You're not getting into anything about propensity with your 276 or your areas of questioning, because of course the case law tells us time and time again that it is a matter of each complainant, each witness will disclose in their own way, in their own time, and there is no guideline for how sex assault complainants are expected to act. So demeanor is of very little value. If you're dealing with an impromptu 278 or 278.92, so you've got some records that you want to use, everybody really should be reading JJ, which is 2022 SCC 28. I'm sure we're all familiar with it, but there's some really good nuggets in that. And actually, I did one last week or 2 weeks ago, and I argued that my go-to position is if I have text messages and they're between the parties, they're probably a record. And I just I want to cut to the chase, and I just want to assume that they're a record, and we're going to get in there and let's just argue about this. And my judge actually, in allowing me to use the text messages, said, and they're not a record. So there's some really, really good language in JJ. I'm sorry, I don't have the paragraph references about what is a record. So just because your complainant and your client were texting, as long as it doesn't have sexual content or even a hint of sexual content, JJ says that you can go ahead and cross-examine on that. And that can be a gold mine for information.
Oh,
so
that's wrong.
The Crown is going to stand up and say, oh, these are records and I haven't seen them before, and let's do a voir dire and everything else. And that's fine. You can surprise the Crown with it. The complainant's in cross-examination. You give a copy to the Crown, you give a copy to the judge, and you go, look, no, it's not a record. And then you're bypassing even having to go down to stage one. And then you're certainly not getting to a stage two where the complainant gets to see them in advance and the complainant has counsel. I did this little list. I was bored the other day and I came up with kind of, if I can find it. I wrote down, and this applies, I think, to all cross-examinations for sure, but particularly when you're dealing with a he said, she said, right? So I kind of called them my 10 commandments of cross-examination. And especially when you're dealing with a witness, like a sex assault complainant, where they can go those yeah, but questions, and they're going to be, in my experience, can be really hard to control until you get to the point where there's a lot of inconsistencies. And like we talked about before, you reach for the transcript and they're already agreeing with you. But when particularly a complainant is pretty consistent with what she's told the police, especially when we don't have prelims now, so there's really not much impeachment between statement and trial evidence, these 10 commandments I think are really, really vital. So first and foremost, be brief. Only ask what you need to ask. Second, ask short questions and use plain words. We're all really smart and we get that. We're lawyers and we know a lot of fancy words, but don't use them with a witness. I think is that you put too much pressure on the witness and you end up having to explain yourself. Only ask leading questions. There's a caveat to that, unless you don't. And what I mean by that is if you've got my example of the yeah, but, so yes, I did tell the police on this date, but I told so-and-so, you might want to follow that up with some open-ended questions just to highlight, because an open-ended question should only be asked if you don't really care what the answer is, in my opinion. And when you could follow it up to make her kind of look like a bit of an idiot, right? Okay, you told your neighbor, didn't tell the police that, did you? No. When did you speak to her? Where were you? What's her name? What's her address? You know, those kind of open questions. And is she here? Do you know she was subpoenaed? To kind of just take that opportunity to highlight the inconsistent or the incredible nature of what she's asking the judge to believe. Yeah, but this didn't happen. Number 4, ask no question which you don't know the answer. Again, the caveat, just what I explained with number 3 with the leading questions. Listen to the answers. Your witnesses are going to give you good nuggets of information, and you don't want to be so stuck to your script that you miss them. Right. 6, and this one sometimes is really hard. Don't fight with your witness. It's really hard. You're like, especially like you think of it, the witness that asks you a question about, well, what would you do? Well, how would you feel about that? Our go-to, right, is we want to be able to justify our position, but it is so much more powerful to just make them look like the aggressor, make them look like the idiot, and leave it. So don't ever fight with a witness. Don't let the witness explain if you can control it. You're going to get a lot of yeah buts, and especially when you're dealing with a he said, she said, it happens quite a bit. Don't rehash the direct examination or the examination in chief. Don't go back over the ground that the Crown has already gone through. And in a sexual assault allegation, whether you're dealing with a child, a complainant, or anybody, I never rehash the rape allegation or the sexual assault allegation, unless and we go back to impeachment, if there's gross inconsistencies. Okay, you said his penis was never in your vagina here, but now you're telling us in court that it was. Like, big things. But don't go back through every little detail, even though you have it crafted out, because you're just letting the judge hear what the Crown wants her to hear, or him hear, again, for a second time. So you want to avoid that. So what I do when I get into the allegation, I do a few inconsistencies if I have them, and then I brown and done her, right? You don't say I'm going to suggest, you're like, you were actually in the living room when this happened. And you were the one that took off your pants, and you did this, and you did that, and you hit the highlights of what you know your client's going to testify to. Number 9, don't ask one question too many. Always dangerous, especially if it could harm you and you don't know what the answer is. And save the explanation for final argument. You are under no obligation to explain to the complainant where you're going or what you're doing. The judge is going to see it if you've got your chapters of your cross-examination kind of mapped out and they know where you're going. But save it for final argument, because again, if you're trying to get that explanation to the complainant, he or she is going to try to come up with a way to try to explain it away. And that is kind of the last thing that we want them doing. So save it for your final argument and pray that your judge is paying attention. And that's why we have final arguments. And cross-examination as a whole, ladies, we know it's about control, right? So preparation, controlling the witness, controlling the narrative. I like chapters or topics or goals. I always have headings with my notes, my bullet point notes, to make sure I get everything out. But you want to kind of play that all the way through the topics to get to your theory. So it's all about control. And if you think about it, if you can't control the witness, how are you controlling the direction that this case is going, right? So you need to bear that in mind with each and every person that you're cross-examining. Perhaps the biggest cross-examinations in the case of a sex assault will be your client, who's crossed for the Crown, and then of course your cross as the complainant. But don't forget about those other witnesses. So if there was previous disclosures to police that were different, you may, and they only have notes in their duty book notes, you may need to call the police officer to get that evidence officially before the judge when your witness won't adopt it. And you're also going to have to think about other civilian witnesses. So maybe there's a friend that she disclosed to immediately, or a nurse at the hospital, or any of those things. So always approach those in mind with, what do I need? What information do they have that I can bring out in evidence that is going to further develop and highlight my defense theory? So in terms of one last thing on sex assault, so I think I do this with a lot of my cases, but more importantly with these types of cases, you remember in grade school, grade 2 or grade 3, and they're like the who, what, where, when, hows, and whys of investigation, or when you're writing a story, you're first learning to develop a narrative, you need to ask those questions. We don't have to prove anything. The Crown has to prove everything beyond a reasonable doubt. But I always ask, why is this person making it up? What's the motive? We don't have to prove motive, but it certainly is nice when we have it. Is there a contentious family court proceeding? Is it a bad breakup? Did he break up with her? Now she's vengeful. Did he sleep with her best friend? Like, why is this happening? Also investigate any types of compensation or awards that they've sought. I've won a couple on the basis that they filed criminal injury compensation board. I don't think that exists anymore, but any social media noise about how they're going to get a payday from this would help. What exactly is she saying happened? When? And who did she tell it to, and where? Know your stage. Be familiar with where the allegation is apparently supposed to have taken place as well, because there might be some impeachment value or some good cross-examination fodder within there. If it's a small studio apartment and she's indicating that there was a large bay window or something, and you know that that apartment doesn't have a bay window, you can take pictures of that. Your client can provide you with pictures. And while it's not on the four corners of the sex assault, and meaning the act itself, it will help you impeach or attack the credibility of a sexual assault complainant. And really, sometimes it's all we have. Our client, we got the person who's saying that this thing happened, and you hope you get a good judge in the middle. that knows that you can believe her, you can disbelieve him, and you could still have a reasonable doubt. So it's about all your cross-examination, everything you do from preparation through to that final submission is all about highlighting why there is reasonable doubt. And I'm going to leave it on sex assault there. I'll turn it over to Kyla, and I'll come back for drugs in a bit.
Natasha, just before we switch to Kyla, because I do see in the chat there's a question about records, because you did mention JJ.
Oh, yes.
And the question here is, my understanding is that you have to argue the records regime when there's a reasonable expectation of privacy. So any biographical stuff, religion, innermost thoughts or feelings, political beliefs is considered a record.
Right. But so what I'm talking, and that's kind of how I've always gone into them as well, Maya. And that's why I'm like, okay, I've got text messages, file my 278.92. Here we go. Let's argue it. It was actually my judge who pointed me to these few, I think it was 3 or 4 passages within JJ and said, it's not a record. They're not discussing not just the sexual nature of it, but there's nothing inherently personal. Right? They're like, hey, do you want to meet up for lunch? So for example, let's say you've got text messages. I was so terrified of him, I never wanted to talk to him again. Not even on social media or on text. And then even a whole bunch of text messages showing that they continue talking for months. Nothing sexual, but it's all about going for dinner, or did you see this thing, or did you look at this article, or whatever, right? Pretty innocuous stuff. Yes, it's got her name and her phone number, but no real other personal religious beliefs or any of that stuff. It's not a record, according to JJ and according to my judge that I just had last week. So I think it's probably still open to be argued, but my read of JJ and then my judge's decision, I think, made it pretty clear. And I think JJ is a bit of a shift towards what we've all been doing and just filing the applications, right? And saying, okay, judge, I want to use this and here's why. And complainant's counsel gets to see it and complainant sees it. I think it's a nice shift. I think we're getting back to a bit more. And I'm thinking about, you remember, this all came about because of Gian Gomeshi case, you remember? So, I was so terrified of him. I didn't want to see him again. You know, I know it took me a while to disclose, but concern. And then Marie Hennon quite skillfully gets the messages and cross-examines them at length about, I'd like to see you tonight. What are you up to? And then everyone went up in arms, and Parliament enacted the 278 and 0.92 saying, no, you don't get to do that. That's how we took it, right? If it's a private communication between 2 parties, you have to give them notice and you have to bring the application. But I'll find the passages, we'll call this, or maybe at the end, that says that unless there's inherently personal information, like, you don't have to bring the application. It's just, I mean, like I said, they're going to jump up and they're going to complain, but JJ seems to be shifting it a bit further back. So going back to Gomeshi, if that was a case where Ms. Hennon had texts that only related to, hey, like my example, can we meet up for dinner? It was really great to run into you at the park the other day. It didn't talk about, oh my God, like there was nothing like, oh my God, I can't wait to sleep with you again, or that was amazing, or anything that could, or have just a hint of some sort of privacy or a private like that kind of private communication, then you would have to bring the record, but not necessarily on the other one. So it's interesting. And I saw a question pop up while I was speaking if I got a decision of it. No, she gave it orally, but she said she was going to release a written decision soon. I'm getting a decision on the trial on June 22nd. Fingers crossed. My client is acquitted. And I will ask her if she's planning on releasing a decision, because I think it's going to, it was a very well reasoned, basically slapped me and said, you should have brought this earlier. You didn't. You're bad. But, you know, I would have given it to you in any event. You don't need me. It's a record. It's not a record for 278.92. Does that answer the question?
Yes, it does. Thank you, Natasha. And there's one more question here. What are your suggestions for approaching a witness that has given very little details and where officers did a terrible job interviewing the complainant?
Yeah, that's tricky, right? So I think it's 2 questions. So one, where the complainant gives very little detail, leaving aside negligence of police for a second, I tend to, I mean, you pray for a prelim. I know we don't get them anymore. It's the kind of thing, wouldn't that be great, ladies, if we were able to flush that out in a prelim like we used to in the good old days? But you can't. So you do a general cross of, you never mentioned that before, you never mentioned that before, you never mentioned that before, that's new to this, that's new to that. You know, it's that kind of laboring cross, and then you go through what you did tell them this fluffy detail, this fluffy detail, this fluffy detail. So just point out some of it without rehashing the whole allegation that is inconsequential information that she did give, but didn't give the fact that he had sex with her at a condom, for example, or something that's like you think it would be mentioned, right? But it's really all you can do with it, unless you've got a particularly malleable witness. Sometimes it's a rare occasion, but I have done this, where you do a kind of a looping cross, right? You almost invite them down the garden path with a few open questions and then go back. And if you've got negligent police who just aren't asking the right questions, I don't tend to highlight that. That's a Crown issue. Let's say they do a completely shitty investigation, and excuse my language, they do a poor investigation, and they only, let's say, take a handwritten statement with a few bullet points and don't bring her in for an audiovisual interview. Then I use that to be, remember those starting questions that I always start with. Details are fresher in your mind, closer to the event, as human experience, as time goes on, memories fade. And then you can stand up at the end of the day and say bad on those police officers, but also bad on the complainant for not coming forward and giving more details that she felt like she wasn't properly heard, right? So you loop it back to her and say, well, you knew who the Crown was in this case, and you had X number of prep meetings, and you met with the officer, and you met with them to prepare for this trial as early as like 5 days ago, and you don't tell them any of this new information, right? No, you don't. So the lingering aspect out there is that she's lying. So I'd like to focus it, use it to diminish her credibility, as opposed to going after the police.
Okay, so I'm going to talk to you a little bit about police officers in impaired driving investigations. And I've kind of broken down my presentation into like the different categories of police officers in impaired investigations that seem to exist, because these are the only ones that in my experience exist. They exist within this spectrum of you're one of these types of officer when you're testifying in an impaired, and that's just the way it is. So I did a PowerPoint on that, and I'm going to share my screen so everyone can see it. Hopefully this works. Okay. Oh. Can everyone see that?
Yes.
Okay, perfect. I'm going to open my door to my car because my laptop's getting really hot. So hopefully you can hear me still. All right. So we're talking about difficult witnesses, essentially, because in an impaired, your police officer witness is definitely going to be a difficult witness. Go on. All right. This is not working for some reason. Okay, well, all right, so it's crashed. That's okay. Oh, here we go. Now we go. Sorry, my computer's too hot. All right, let's try this now. So the first one is the officer who will always say things like, if you say so. So usually when I'm doing an impaired driving case, I'll be putting to the officer things that either they didn't see, indicia, symptoms, or things that they said that might have amounted to like creating confusion over 10B or charter breaches. And some officers love to respond and go, if you say so. The practice with impaired driving cross-examinations is often to try and pin the officers to whatever's helpful. It's either omitted or included in their narrative reports and their notes. And so, oftentimes you'll get these officers who will say, in your notebook, you didn't record any odor of liquor. And they'll say, if you say so. So you never let them get away with this. This is like a trick that I'm reasonably certain they're taught for how to get out of agreeing with what you're putting to them. So I always repeat the question and apologize to them. I'm sorry, Constable, I didn't get your answer. You didn't record the odor of liquor in your notebook, is that right? And then if they still go, yeah, if you say so, you repeat each fact that forms the foundation of the question one by one and re-ask the question. And if that still doesn't work, then you say, well, Constable, I am saying so. So you agree that you didn't record the odor of liquor in your notebook. And at that point, they look stupid. Like they look like they're being obstructed. The judge is ticked off at them. They feel like they're going to get in trouble, and then they'll agree with it if they haven't up until this point. But don't ever let them get away with this, because if you say so is not agreement, and a judge won't treat it as agreement in court. The next thing, the witnesses who just do not remember. Oh, I've done so many traffic stops, I've done so many impaireds, I can't remember whether or not there was slurred speech. There might have been, I don't remember. You've got to go back to all the details that they testified about that they do remember, usually the ones that are helpful to your client, and confront them on why important details to your case are omitted from their memory. Like, oh, well, you had no trouble remembering these things, and then all of the things that are bad as well. You had no trouble remembering the odor of liquor and the balance problems, but you say you can't remember whether or not there was slurred speech. And you can even ask them, like, why is it that only details that might be helpful are not in your memory, constable? You get slapped for that question, but you're making a point by asking it, even if the judge will tell you the witness doesn't have to answer it. The other thing you can do is you could just use it to undermine their reliability. If they want to play the I don't remember things that help you game, then you can just confirm what a poor memory they have and how terrible they are at remembering things and how unreliable and fallible their memory is. I usually use the line, memory by its very nature is the faculty that forgets, which actually comes from a note-taking case out of Ontario. I just like the way that they describe that. And, usually there's enough big words in that they're not entirely sure what you mean. So they just agree. And then, you get them to agree that they have a poor memory, and then everything that they're remembering that's bad to your client is probably unreliable because they're probably confusing it with the details of another case. And you can also, of course, go back to your impeachment, or refresh their memory by something that they recorded before. That's your I don't remember police officer. Then you have the classic male police officer overtalkers who, you're not even finished asking the question and they already think they know where you're going to go, and they start talking and they just won't shut up, and they think they're answering what you're going to ask, and you're probably not asking that anyway. I just let them talk. Let them go. I'll lean on the podium and stare at them. And then when they're done, go, okay, are you done? So what I was asking, or sometimes I just turn my back to them and walk away. I literally just turn around, walk away, dig through my briefcase. Like, I'm not even listening to you anymore. You're just talking over me, and I'm not paying attention to what you're saying. I'm actually listening very carefully because usually they're telling me something that I want to hear. But they think they're outsmarting me and or over talking me because they think of that, and it ends up working to their detriment. The other thing that is a weird psychological trick that you can use with these types of witnesses is they're talking and talking over you. Put your hand up like this, like a stop sign. Just stare at them, and they will stop talking because they're all like paramilitary organization people. So they get a hand signal to stop, and psychologically they are trained. Oh, I need to stop, and they don't even remember. Sometimes you can also wait for them to finish and then go, Constable, do you remember when my friend was asking you questions and you listened very closely to the question that my friend was asking, and you did your best to answer my friend's question, specifically what she was asking you? Okay, well, now it's my turn. So now you have to do that for me. And then they feel very small, like they've been reprimanded. Or you can just re-ask the question when they're done talking. And again, listen very carefully. Do not look like you're listening. Do not act like you care, but listen very carefully, because what they're saying is probably going to be useful to you, but you don't want to sort of empower them to keep doing it by making them think that it is helpful to their case or that it matters to you. The interjectors, these are similar to the overtalkers, but the people who will just interrupt your question. They don't keep going, but they interrupt. Do not let them control how you ask the question. As soon as their interjection is done, go back to where you were in your question and finish your question. ignore the interjection until you have your answer. And, you know, if you continue to get it, you can explain your role and the witness's role to them, put them in their place. I sometimes also like just tell them, oh, I'm sorry, constable, you have to wait until I'm finished talking because there's a recording and the recording doesn't pick up two people at once. So you just need to wait. Otherwise, we don't get a good recording. And that often will stop them from interjecting and interrupting because they think they're actually like wrecking the court process, which is true. It does do that, at least in BC. I don't know about other provinces, what you guys use, but it's, you know, it's just a control tactic. You can also ask them about how they desire, like what their desire is to participate in the process. A lot of police officers really don't want to testify in an impaired. They don't want to for several reasons. One, they usually actually don't care that much because they do a lot of them and they'd rather be on the road and it's really boring. And the other reason is they're terrified because they get raked over hot coals in a way that they don't in other types of cases, except like maybe drug cases. And they're asked more to answer for their conduct. And the less time that they're on the stand, the less likely they feel it is that they're going to maybe be caught in something that could have negative career implications. So you can just, and this also works for civilians too, you can just tell them, like, if you listen to my question and let me finish and answer my question, I'll get you out of here faster and you'll get more of your day back. And people love that. People are like, how can I get out of court sooner? I also want to get out of court sooner, so I get it. And then, of course, you can also just ask them why. This is like one of the rare occasions where a why is totally okay. You can say, Constable, why do you feel the need to keep interrupting me? They won't have an answer and they'll feel embarrassed about it. And then there's the pontificators. Expert witnesses often will fall into this category where if you ask them a simple question, like, you know, what type of breathalyzer did you use? That's a terrible question. Don't ever ask that. But, you know, just like a simple question that should be like an Alka-Seltzer FST or whatever. They will say, well, you know, in British Columbia, there are breathalyzers that are approved for the BC Motor Vehicle Act, but there's also federal approval. And we used to use one called the Alka-Seltzer Alcometer SL2, and then we switched in the late 90s to the Alka-Seltzer 4 GWF, and like they give you this whole like stupid history lesson. And just let them talk. Just tell me everything. And with experts, this is the best strategy. I love getting an expert to talk because they usually end up telling me things that are defenses because they're not thinking about the theory of the case. They don't even usually know what the theory of the case is. They just know the stupid science. And so they're talking about the science, and they're either going to tell you something that's not actually supported by all the science that you've researched that then you can confront them with on studies and prove that they just make stuff up, or they tell you something really interesting about how the science actually might benefit your client that you didn't even know, that you didn't encounter in your research or consulting your own experts. So let the pontificators go. I love it. And they waste so much court time. And do you know what else is great about the pontificators? Is it's not your fault when you're cross-examining them. That's a Crown witness. You're in the Crown's case. If the Crown's case doesn't finish in time and there's delay, there's a Jordan issue, and that's your friend's fault. How could I possibly know that their witness would take 15 minutes to answer a simple question? And then, you know, you can also ask them why they're having difficulty with a simple yes or no question. I'm sorry, Constable. I asked you a yes or no question. Did you see any problems with Mr. Smith's balance? Why is that a difficult question for you to answer? The other thing that you can say is, we'll get to that. Let them say everything and they go, okay, we'll get to that. But what I asked you was this, and we'll get to that is the line that strikes fear into the hearts of police officers, because what you've told them, usually it's not true and we're not going to get to it, but what you've told them is, I've already thought about this and I intend to go there and I'm going to ask you something about this that you probably don't want to be asked. And so then they get scared and they tend to like actually withdraw and be less of a pontificator. Or you can just go, so that's a yes. Yes. And with pontificators, do not try to impeach them mid-testimony. Wait until the very end when they've worn themselves out on talking, when they've said as much as they can possibly say about everything before you get to your impeachment. So if you get a police officer that's one that likes to really describe everything in excruciating detail, wait. Do not try and impeach in the middle of their testimony, because they're the same type of people, similar to the witnesses Natasha would talk about, that will go, yeah, but, and they will go on with like 50 different buts, and you won't have a good opportunity to impeach because they will have thought through everything. Whereas if you've let them run it all out, they're out of ideas. The extremely accurate witness. This is a true story. I had a witness once. It was a drug file, and the officer was testifying about where like the car where this hand-to-hand had parked. And I was trying to get the location because there was like questions of observations and a glare off a windshield. Anyway, it was the whole thing. And I said, okay, so when the car pulled up in front of the apartment building, it parked on the shoulder. No. Okay, it stopped in the roadway. No. Well, it's either on the shoulder or in the roadway. Where was the car? It was half on the shoulder, half on the roadway. That is when you whip out your best 13 years old eye roll that you perfected when you were a teenager, and you just let it rip. Because honestly, that is the stupidest way to answer a question, and it makes you look like you're playing games, and the eye roll communicates to the judge that you feel like the witness is playing games. And if they do it a few times, you can just stop and you can look at them. And I heard a lawyer ask this question once and get away with it. Constable, why do you feel the need to be cute with your evidence? I tried it once and I did not get away with it, but it doesn't matter. Like my half of my cross-examination is doing stuff I shouldn't get away with and not getting away with it. It doesn't matter if the judge lets you ask it. It's about your relationship to the witness, and it does get you where you want to go with the witness. So I don't care if the judge doesn't make the witness answer. Argumentative witnesses. Lots of police officers will argue with you. You know, one of my favorites was no odor of liquor in a impaired case, and I was putting to the officer that there was an odor in lunch, and I said, you know that such an odor doesn't indicate any alcohol consumption because it's not coming from the person or their breath. And he goes, yeah, but it does when you take them back to the detachment and they blow 240 times 2. So you can go like full Dodd method on these people, and like for those who don't know the Dodd method is like this extreme, like one fact per question. He teaches it in a way where like he'll ask you to talk about what the witness is wearing by doing one detail about it at the time. You're wearing a shirt. Your shirt has a collar. Your shirt has buttons. All of that until you get what you want. So you can just break it down, go super slow, get every excruciating detail one at a time out of that witness, because that's the only way with the argumentative witness. You're going to box them in where they want. And if they continue to be argumentative, you can say, you know, Constable, you were trained on how to give testimony in court. You were trained on being cross-examined by defense counsel. During that training, did somebody tell you it was your job to disagree? They're going to say no, but it doesn't matter. You're planting that seed. And then you can ask them, well, what were you told the purpose of testifying was? And they're going to tell you something that is not what they are doing. And then you're going to say, okay, well, let's see if we can try that now. Of course, it's always fun with these police witnesses, especially in impaired cases, to ask about the training they received about being cross-examined, because I guarantee you in depot, for RCMP officers, I don't know about OPP, but for RCMP officers in depot, they're all given training specific to answering questions in cross-examination on impaired driving investigations. When they get their roadside breathalyzer training, they are given cross-examination training as part of that. So ask them the questions about what training they received, and that usually will sort of beat the argumentativeness out of them because they were trained not to be argumentative. This is one of my favorite answers that I get from police officers often. Oh, I didn't write it down because I didn't know it was important. Well, it usually is important, and that's why they didn't write it down. This also applies if the police officer says, well, it wasn't my investigation. You know, you get two police officers rolling up and one's doing all the demands and the testing and the other one's standing there and they take like the worst notes and you're like, you weren't even doing anything. You couldn't write anything down. Well, it wasn't my investigation. Okay. So you can, admonish them about everything that's happened since. For like civilian witnesses, you can confirm that they reported a crime, that they were asked to give a police interview, that they talked to other people, that they gave an interview to a prosecutor. At some point, it had to hit home to you that it was important. For the police witnesses, you get there a lot faster. Well, I mean, as soon as you effected an arrest, constable, you had to know this was important. I mean, your job is to enforce the law. You know that enforcing the law is important. So you did know it was important. And you didn't record that there was any slurred speech. And that's because there was no slurred speech. Is that right? Great, thank you. And then this is my favorite, the stupidest justification for everything that the officers didn't do. If they can't get away with all these other stupid reasons for not agreeing with your evidence, they'll pull out the trump card, which is officer safety. Everything was officer safety, officer safety, officer safety. They always try to justify it that way. And you can set it up well in advance. I put this right at the beginning of my cross with officers and impaired driving investigations, all the reasons why there were no officer safety concerns. There were two of you. My client was a 110-pound woman. You handcuffed my client really quickly. My client was cooperative. You didn't feel the need to use handcuffs. You were armed with a gun. You usually Crown's got that out on the voluntariness stuff, but you had a gun, you had a baton, you had pepper spray, you had a conductive electric weapon, you had all of these other methods for compliance. So, and you didn't use any of them. You weren't required to use any of those. You had no concerns for your safety. And if you do that early in your cross, before they're going to get to the point where they're saying, I didn't write this down, or I didn't do this charter compliant action because of my very big concerns about officer safety, you are going to set it up for that justification to look fabricated. And I had a trial recently where the judge ruled that the officer safety justification was completely illegitimate because the officer literally let my client rifle around in the back of his van for 15 minutes before reading him his Section 10A rights. And then he's like, well, there's also officer safety at the detachment, when he was trying to limit opportunities to access counsel. I was like, but you stood at the roadside with him for 15 minutes, right? Like, we went through that and you had no officer safety concerns then. So then when he was in the detachment and you'd searched him and you booked him in, there was no officer safety concern. The judge was like not buying it. And then you have the people who love to ask you a question in response, which not a lot of police officers do this, but some will try, especially when they're really feel like they're being attacked. And you can remind them whose job it is to ask the questions in the courtroom. It sounds really snarky, but it's the perfect time to be snarky because they're being snarky. And I know Natasha says don't pick a fight with a witness. That's sex assault witnesses. You can pick a fight with a cop as long as you have the, higher ground in that fight. And the fight of, well, okay, constable, it's my job to ask the questions and it's your job to answer them. So I'm going to ask you again. And then you can also answer the question yourself. I'll have an officer sometimes say to me well, you've never blah, blah, blah. And sometimes they make stupid assumptions, right? They assume that we do this work because we've never been victims of crime or that nobody's ever killed one of our family members in a drunk driving accident. That's probably not true for the vast majority of us. So I'll often say, actually, I have. So I'm going to ask you again. Right? Just answer the question. You don't lose your power necessarily by answering the question, especially if they're asking a question to you because they're making an assumption about you that's not accurate. And then you can go back to that same thing of, I don't want to keep you longer than I have to, and I only want to ask the questions I need to ask, and then I'm going to send you home. So can you please do that for me? Answer my question so I can let you go home. And then I know I didn't put slides in for expert witnesses. So let me see if I know how to stop my share here. Okay. But yeah, with expert witnesses, usually they fall into that pontificator category. And my general theory with them is just keep them talking, keep them talking, keep them talking. And, I think I said this in the prep session, which is if you have an expert testifying, make sure you know more than they do about their field of study before they start talking. but do not act like you do. I love to play stupid when experts are talking. Like I love to act like I'm just hearing all of this for the first time. Like, what's a fingerprint? A fingerprint's like oils and stuff. Can you explain that to me more? I totally didn't understand any of science in school. And like playing the dumb little girl card usually works quite well with experts because the vast majority of them are older white men who get this really like paternalistic thing towards you. And that's super fun. And they love to educate you. Experts have no personality. I have never ever had an expert on the stand who was an interesting person. And so because they're so dry and boring, the more personality that you have when you're talking to them, the more you're actually going to bring out of them. So amp up your personality game when you're cross-examining the expert, because it will actually get more out of them, in the same way that like if you're at a bar and you're talking to somebody who's really boring and you up your personality 10 ways from Sunday, you're going to pull them out of their shell. And that is sort of how I deal with that. So I have some slides on social media, but I think I'm going to turn it over to Natasha for the next part of her.
Thanks, Kyla. And I don't, it's funny. I think everything that Kyla said, because we're dealing with police officers, really applies to drugs as well. See, it's all of that. If you say so, and yeah, it is a different cross-examination when you're cross-examining a surveillance officer or a drugs expert or any of those things than when you're dealing with, I call them more vulnerable. They're not necessarily always vulnerable, but the more vulnerable witness that you might see in a sex assault case, like a mother whose daughter's disclosed to her that stepdad did this horrible thing, and then the child, and et cetera, et cetera. So you need to, I always keep coming back to preparation, but preparation really is key. You've got to do everything that you can. So when you get a drugs case, you need to consider what you're missing. So is there an ITO? Is there a search warrant? You've got to dissect that search warrant. Will you bring a Dawson application, which is leave to cross-examine the affiant of the prelim? Will there be a Garofoli, leave to cross-examine at trial and attacking the warrant internally and externally? Another thing is that comes up in these drugs cases quite a bit are those surveillance officers, and they're a different breed. They're kind of like TAC officers, right? They're the men's men, and we're the bro club, and we're here, and we do such great work, and we do this, and we do that, and inevitably they will mess something up, and they'll let the testosterone get to their head, and they'll give you some good little nuggets. So what I do, Crowns, I don't know if they do this in other jurisdictions, but I find in Eastern Ontario that Crowns are like, hey, we've got 20 surveillance officers because he was followed for like 2 weeks. Do you mind if I just call one from each day for the observations, or just one, and he can testify to the observations of others? I mean, there's nothing really contentious in there. I'm like, okay, we can do that, but can you undertake to me that if my client is convicted, that you're not going to ask for more than 6 months jail or 2 years jail or whatever the number is? Like, no, ridiculous. Of course I can't do that. Well, then I'm not letting your hearsay go in either, right? Like, we're the ones that are always forced to like streamline, and why are we calling these people? And it's all on our client to make all of these concessions to make the inevitable, what the Crown hopes, conviction of our client easier. And I just say, no, call them, because you don't know. The fact that there was a girl in a gray sweatshirt might not be important on paper, but then when you come up from your cross-examination of other witnesses, it is, and it can be kind of evolving. So no, if you're going to make an admission, other than my view, other than date, ID, and jurisdiction, it's like, okay, I could do that, but what are you giving me in return? What are you giving my client for doing that? We're not there to make their jobs easier. We're there to protect our client. I said something, and this comes up with drug officers all the time when the witness wants, especially these drug guys too, or police officers in general, they think they know what you're trying to get at, right? And so instead of just answering the question, which is where you parked on the shoulder, or was he parked on the road, they give you the nonsensical answer. Then they start, and then he gives you a full explanation for why he feels that way. They're always going to try to get where you're going. And Kyla said, I'll ask you about that. But what I do is I get even a little snarkier with these witnesses. And you can have a bit with a sex assault complainant too that keeps going off, and you got to keep bringing her back. And what I'll do is I do this. I didn't even realize I did it. My associate pointed it out the other day when he was taking notes for my cross of her, and I kind of lean in on the podium, and I got my pen. I'm just kind of waiting for her to finish, and I do the little hand thing. I'm like, okay. I said, trust me. And you do like kind of a bit of a smirk and a chuckle, right? Trust me, Ms. X, we're gonna get there. I've got lots of questions about that, right? And really kind of exaggerate, like, I promise you, I'm not gonna be unfair to you. We're gonna spend a lot of time about that. So you're building up that fear, right? But you're also highlighting to the judge that she's being ridiculous. So I like the trust me, we're gonna get there. Kind of a condescending way, but it kind of alerts the witness and makes her a little bit uncomfortable, or him uncomfortable. Oh, Kyla, just had a note for you. Said that expert witnesses don't have personalities. You need to do homicides. Pathologists, reeking with too much personality. They seem to always have tons of personality, maybe a bit too much. So it's just a different kind of expert, I think. And you typically, your drug experts, not to take too much of Kyla's area, but they're going to be police officers, and they're typically police officers in the same division, in the same force, in the same city, and they're on the same team, right? So that idea, I mean, we've all seen that Dr. Woodside DO assessment thing in the case law that went around this week in Ontario, but it's a different issue, but it's kind of about unpacking that, right? It's about unpacking the relationship, unpack how they became involved in this. Are they really arm's length? Do they really understand their obligation to just proffer evidence? And unlike pathologists or other types of experts in my practice, I typically don't admit the expertise of a drug officer ever. Like, no, we're going to have a remote hand voir dire. We're going to figure this out, and you're going to flush it out. And even if the person ultimately is qualified as an expert, you put the screws a bit to this witness in the voir dire, so they already know what's coming for them, and they're already going to be a little bit more on edge. I think, Kyla, you really did. Thank you. You covered everything else I was going to do on drugs. It really does hit with police witnesses as well. So I'll end it there.
Okay, then I'll just spend our last few minutes here talking about some tips for using social media to investigate your witnesses. And this really applies to your police witnesses as much as it applies to your civilians, although I typically tend to use this more with civilians. Although I have found that when I do this for police witnesses, I discover a bunch of McNeil evidence often that was never disclosed. Like, I had one police witness who they didn't disclose any McNeil to me, even though he'd been convicted criminally of assaulting his partner, had driven drunk from a party and went to his house and took all her stuff and burned it on the front lawn. Because he found that she was banging the tennis instructor. Like, you could not make this up. And it was all in a news story. And I did not get it through McNeil, so I cross-examined him on it, of course, by setting it up by saying, you were mad because my client he'd seen him driving without a seatbelt earlier in the day. And he thought, oh, I'm going to get him, and he couldn't catch up to him to pull him over in time. So he set up a roadblock to look for seatbelt infractions. And I was like, you were mad because you couldn't stop my client. And so you set up a roadblock as revenge. He's like, I don't get mad. I'm like, you don't get mad. No, I don't get mad. You never get mad? Never. Let's talk about a time you get mad.
Ooh, that's good.
Yeah. Yeah, that was fun. Anyway, so yeah, always Google everybody. I love Google. I don't know about Ontario, but in Alberta and in BC, you can search, there's public or lawyer ability to search court records. So I can search all of the civil filings and all of the criminal and traffic ticket matters involving a person. So I'll look up the witness's history of traffic ticket disputes and see how many times they've gone and been found guilty of a speeding ticket. You can't see their entire driving record, but you can at least find the times that they've disputed a ticket and lost. You can find all of the lawsuits that are filed against them and learn all sorts of interesting information that you can then use against them. But social media, I feel like, is an untapped resource for us. So quickly share my screen, and hopefully this works better this time. Sorry for my incompetence. Okay, using social media, getting results on social media. So usually if you can locate one profile for a witness, and usually you can do that, right? Like usually you can find like their locked Facebook account or their TikTok page where they haven't posted any videos or something. You can find their other stuff. You can go through their friends list. And if you go to the bottom of somebody's friends list, like the first 5 or 10 friends or followers that they have, or people that they followed on an account, you know, barring the celebrities that everybody likes to follow, you can usually find close friends and family members are going to be in your first 5 to 10 follows. And then you go to those people's pages and you start digging through those people's pages and finding all the comments that your witness has made, or even the other profiles that they're using to make comments where they maybe don't use their real name. Like for me on Facebook, I'm Kyla because I don't want my clients finding me on Facebook. But you know, it would be very easy to find that that is in fact my Facebook account. If you know, look through the people I'm friends with on other social media platforms, you can find my family members, and then you can find me on Facebook. So very easy to do. Look for people with the same last name, or people who have like maybe a middle name that's the same, because usually that's, you know, somebody who's married and they put the middle name in there, which is actually their maiden name. And also check out the comments that they posted on other accounts. I find all of this stuff useful, and I'll like print it all and stick it in a lovely little folder of awful stuff about the witness, like, you know, racist things that they wrote, bragging about violating the law. I think I told this story before, that I had a guy who was like a security guard, and he was an aspiring police officer who'd showed up first to an accident scene and was like dealing with my client and had some damaging things to say. And he posted bragging posts about beating up shoplifters in his security guard job. And so I printed all those things and started crossing him on how he basically just wants to be like a Keystone Cop one day. And he phoned the Crown at the end of, it was not the end of his cross, like the end of the day. And when he was obviously under an order not to talk to the Crown, but he phoned the Crown for the sole purpose of saying, "I won't come back. She's being too mean to me." He had to come back, obviously. So find that stuff. Find them bragging about violating the law or violating charter rights, or, you know, saying that charter rights are stupid. But lots of police officers make lots of comments on social media about how stupid they think that the right to counsel is, or how awful they think defense lawyers are, or all sorts of stuff like that. And that is great stuff to have. Bragging about lying and getting away with it, you know, oh, I told my mom that I was out at my friend's house, but instead I was at a rave or whatever, right? Like kids post stuff like that because they block their parents from the social media category profiles, or they like put it on a limited profile, or they have their, oh, what do they call them now? Their Finstas. And they brag about this stuff, and that's great because you can show that they lied in the past and they're the type of person who lies to get what they want. Posts, I always look for the time of the incident. Whenever the event happened, I look for their posts like in the days and weeks after to see if they posted about it, but also to see if they posted anything that would contradict what they were saying about how it affected them. You know, like complainants in impaired bodily cases who you know, oh, it was so horrible I couldn't get out of bed, and then there's like a post like 3 weeks after the accident, they're like lying by the pool in Mexico, and you're like, well, yeah, you couldn't get out of bed because you were in paradise. Show them that they're not bogged down by injuries, or even, you know, like we saw in the Johnny Depp Amber Heard defamation trial, photos showing that they didn't have the bruising or the injuries that they claimed to have, that so weirdly the police were not able to successfully photograph. So weird. Or trash talking your client, always good stuff when they're trash talking their ex, or trash talking the dirtbag drunk driver who ran over the whatever, you know, the stop sign. And anything that suggests that they have a motive to fabricate. We have this stupid public insurance company here in BC. Oh, I don't want to keep you guys too long. Sorry. We have this stupid public insurance company in BC that files pro forma responses to every motor vehicle injury lawsuit blaming the victim. I use those in every crash case. I'm like, look, ICBC said you weren't injured and that it was all your fault. I mean, the judges kind of roll their eyes, but I don't know. It gets me some concessions on cross-examination. So it's good. Check the comments. You can also use companies like Friends Plus, Hootsuite, Sprout Social. You have to pay for them, but they will actually do more deep dive searches into people's social media profiles and the comments that they've made, but the search engines within social media platforms are really powerful. So Facebook, you can actually write like comments by Boxcar Kyla and then see all the horrible shit I've posted in comments on Facebook. And you could also do like likes by Boxcar Kyla. So if you see a police officer, maybe they don't comment a lot, but they like a lot of right-wing stuff, that's cool. You liked this post, you liked that post, you liked this post. You can use all of that stuff. You can also Google usernames and search them on Reddit and Discord to find comments that they've made there. And the Control F button works on Facebook and Twitter. So you can search an entire tweet history for certain search terms or words that might be of interest to you. And those are my tips on social media. And that, I think, is everything we have to say